Okay, everybody, welcome back. I'd like to bring up panel number 3, our final panel for the day. We're really looking forward to your presentations. We've had a great day. Fingers crossed our technology stays with us. So this panel is called Lived Equality Beyond Formal Political Rights. And our moderator for this panel is going to be Quentin Morse. So Quentin, the ball's in your court.
Thank you, Professor Malvo, and good afternoon, and welcome to the third and final panel of the day, Lived Equality Beyond Formal Political Rights. We are thrilled to have 4 distinguished panelists with us today, but before I introduce our panelists, I want to remind everyone that after the presentations, our Zoom webinar audience members will be able to submit questions during the Q&A session. With that in mind, I want to introduce each of our 4 panelists. The first of our 4 speakers is Ezie Gruber. Professor Gruber teaches criminal law and criminal procedure at the University of Colorado Law School, where she has taught since 2010. Former public defender, Professor Gruber's scholarship focuses on feminist efforts to strengthen criminal law responses to crimes against women. Her forthcoming book, The Feminist War on Crime, The Unexpected Role of Women's Liberation and Mass Incarceration, tells the story of how feminists, in their quest to secure women's protections from domestic violence and rape, ultimately contributed to mass incarceration, and it sketches a path forward for how to oppose violence against women without reinforcing the American prison state. A frequent public speaker on criminal justice, Professor Gruber has appeared or been quoted in various news outlets, including PBS, NPR, ABC, The New Yorker, Slate, and The New York Times. Our second panelist today is Chinyere Ezie. Chinyere is a staff attorney at the Center for Constitutional Rights, where she advocates for racial justice, gender justice, LGBTQI rights, and challenges governmental abuses of power. Prior to joining the Center for Constitutional Rights, Chinyere worked at the Southern Poverty Law Center and as a trial attorney at the U.S. Equal Employment Opportunity Commission. In 2016, she was named one of the nation's best LGBT lawyers under 40 by the National LGBT Bar Association. Chinyere is a William J. Fulbright Scholar and a graduate of Yale University and Columbia Law School, where she was an Alexander Hamilton Scholar and served as editor-in-chief of the Journal of Gender and Law. Our third panelist today is Diana Flynn. Flynn is the litigation director at Lambda Legal, the oldest and largest national organization dedicated to securing the rights of LGBT people and people living with HIV through impact litigation and public policy work. Flynn came to Lambda Legal in early 2018 after serving more than 30 years at the U.S. Department of Justice Civil Rights Division, most of them as chief of the appellate section. Flynn has garnered numerous awards throughout her career, including the U.S. Attorney General's Marshall Award for providing legal service, the Attorney General's Distinguished Service Award for exceptional service, and the Department of Justice's James R. Douglas Award for contributions to the work-life environment for LGBTQ employees at the DOJ. Our fourth and final panelist is Scott Skinner-Thompson. Professor Skinner-Thompson teaches constitutional law and civil rights here at the University of Colorado Law School, where he has taught since 2017. Prior to joining the Academy, Scott served as co-counsel with the ACLU's LGBT and HIV Project, the Center for Constitutional Rights, and the Transgender Legal Defense and Education Fund. Scott's research interests are in constitutional law, civil rights, and privacy law, with a particular focus on LGBTQ and HIV issues. His scholarship has been published in the Georgetown Law Journal, Michigan Law Review, Northwestern Law Review, University Law Review, among others, and he is the editor and contributing author of AIDS and the Law, one of the leading resources in the field. Please join me in welcoming our 4 distinguished panelists. With that, I would like to hand the reins off to our first panelist of the day, Professor Gruber.
Thank you so much. I'm so grateful to be a part of this conference. So I want to thank Scott for inviting me, and Suzette and Melissa and Quentin and the students and the IT crew, and all of you who are participating in this stressful and uncertain time. And as I speak to you, I am so well aware of my privilege to be here in a home, housed, warm, with my family, safe and healthy. And I am also well aware of just how many people do not have that privilege and need it so badly at this time. So you know, it's been a wonderful break from these scary times to be able to stream. I've been streaming on YouTube this conference and to think about something celebratory. That is the centennial of women's enfranchisement. So since this is a celebration, it might seem a bit strange that I'm going to present ideas from my book, which is somewhat critical of the women's movement and somewhat critical of certain aspects of American feminism. And so here's a shameless plug for my book. It is The Feminist War on Crime, The Unexpected Role of Women's Liberation in Mass Incarceration. And it takes a deep dive into the complicated relationship between feminism and the US penal state. And it officially comes out in June, but you can order it now and it's shipping. Okay, so this panel asks us to go beyond formal rights and think about how to achieve lived equality, or I would say lived justice. Now, some speakers have and are probably going to go back and talk about the unfinished business of feminism. But I want to go back in time and talk about some of the finished but misunderstood business of feminism. The story of feminism is not one of a linear march forward from past oppression to future utopia. It is a story of contestation, complicated alliances, and strategic compromise. It is a rich story of simultaneous participation in and resistance to institution of power, and legal reforms that reinforce larger inequalities, even as they produce justice for individual women. Now today, much of feminism is carceral, meaning incarceration-centric. And that's a problem in today's world where incarceration is a death sentence. Sociologist Elizabeth Bernstein coined the term carceral feminism to describe the late 20th century feminism's, quote, drift from the welfare state to the carceral state as the enforcement apparatus of feminist goals. This carceral position, I argue, stems at least partly from feminist embrace of a particular historical narrative, which, although widely accepted, is incomplete and not fully accurate. In the conventional feminist account, the history of domestic violence and rape law is one of under-enforcement and widespread legal and social tolerance of violence against women. And the few feminist efforts there were feeble and failed. This narrative prefigures a common modern sensibility that the feminist position must mean stricter policing, prosecution, and punishment. In short, the past was sexist, past criminal laws were weak, and thus feminist progress means strengthening law enforcement. But as our historians so beautifully pointed out this morning, history is rarely simple. Early American law prescribed harsh punishments for rape and domestic violence, and these laws were not under-enforced so much as selectively enforced, even over-enforced, depending on the marital status, class, and race of those involved. Moreover, feminist criminal reform is as old as American feminism itself. Concerns over rape, prostitution, and domestic abuse lay at the very heart of the first wave of feminism and played no small part in suffragists' quest for voting rights. Early feminist reform efforts were quite successful, and they interfaced with larger political phenomena, from social purity to slavery. So let me tell some stories that highlight this complicated history, and then I'll turn to the present. So many here might be familiar with the temperance movement of the late 19th century and the Women's Christian Temperance Union's crusade against vice, which was alcohol and sex. But also in the 1890s, the Union president, Frances Willard, launched a successful campaign to raise the age of consent to sex to prevent seducers from ruining young women and forcing them into a life of prostitution. Now, the critical take on this is that Willard was just trying to protect Christian morality. However, Willard, like modern feminists, saw how seduction and prostitution harmed women, including lower-class girls. Yet at the same time, her anti-rape efforts occurred at a moment when rape law constituted racial terrorism of Black men in the South. Rape-based lynching was so copious as to occupy the agenda of prominent Reconstruction-era reformers like Ida B. Wells, who argued that white men used the ownership of the body of the white female as a terrain on which to lynch the black male. In 1894, Wells went to Britain to drum up support for her anti-lynching initiative. And while there, she got into an infamous row with, of all people, Frances Willard, who was also touring Britain on behalf of temperance. Wells rebuked Willard, telling liberal Brit aristocrats that when Willard went to the South to support her age of consent reforms, she made racially charged sentiments and even encouraged the lynch mob. Willard responded by accusing Wells of harboring anti-woman sentiments and enlisted high society to suppress media coverage of the criticism. Now, the women's movement's anti-white slavery crusade also exposed racial and class rift. And this morning, Carolyn Ramsey talked in detail about some of those rifts. The female sex workers at the center of reform efforts, even as white, but especially if minority, easily slid between victim and criminal. Temperance activists lamented that the sexual slaves, although victims, were also perpetrators of harm who tempted husbands into debauchery and brought lust and disease into the marital home. Such debauched women needed to be reformed, redeemed, and hygienized. The divide between prostitutes and their rescuers had a particularly eugenicist bent on the West Coast. In the 1870s, as the Chinese population in California neared 25% and fears of yellow peril was in full swing, Asians' perverse sexuality figured prominently in anti-immigrant rhetoric. California state legislators pressed the yellow slavery narrative to secure strict immigration laws. One state newspaper remarked, quote, "Chinese females who immigrate into this state are, almost without exception, the vilest and most degraded class of abandoned women." It goes on. "These women exist here in a state of servitude, beside which African slavery was a beneficent captivity." This moral repulsion met with hygiene-based fears of exotic Chinese viruses. In 1876, Dr. Hugh Tolan, founder of the University of California Medical College, testified to lawmakers that Chinese prostitutes were the cause of 9/10 of syphilis cases, and that his patients believed that, quote, "diseases contracted from China women are harder to cure." One pamphlet warned that, quote, "commingling with Eastern Asiatics creates degenerate hybrids." Meanwhile, activists worked to rescue the small pool of Chinese women in California. Many of these Chinese emigres regarded the move to America as a chance for a better life. Historian Peggy Pascoe observes that, quote, "the highly skewed sex ratio in immigrant Chinatowns and the absence of established in-laws created unusual opportunities for immigrant prostitutes to marry and leave prostitution behind. But owing to xenophobic stereotypes, policymakers saw Chinese women's degraded status as something cultural, even innate." Law professor Carrie Abrams puts it bluntly, quote, "if Chinese men were innately coolies, willing to indenture themselves into servitude, Chinese women were innately prostitutes, willing to do the same thing in sexualized terms." California legislatures, quote, "vowed to prevent the importation of these female coolies." And in 1874, California amended its laws to give immigration officials power to exclude, quote, "a lewd or debauched woman." But a court case shortly found that the federal government had sole authority over immigration. In response, Congress swiftly passed the 1875 Page Act. It was the first federal law to control immigration, and it forbid, quote, "the importation into the United States of women for the purpose of prostitution." The act required new forms of governmental surveillance, detention, and enforcement authority, and it produced the virtual exclusion of Chinese women from the United States. Historian Ithne Lupide notes that, quote, "immigration enforcement strategies, which were pioneered on Chinese women, because of fears of their sexuality, gradually became extended to every immigrant who sought to enter America. So that was then. Let's talk about now. With a myopic view of history, feminists are destined to repeat the mistakes of the past. Today, women's rights activists and law enforcement agencies prioritize cracking down on human trafficking, once again called slavery, and once again imagined as poor foreign women held in physical bondage. The modern anti-trafficking consensus is so powerful that Trump has touted preventing trafficking as justification for the wall. A couple of years ago, the media was abuzz with the arrest of billionaire Patriots owner Robert Kraft, who was caught receiving sexual services at Orchids of Asia Spa. Florida police had been ramping up anti-trafficking enforcement and targeting spas, which they officially referred to as the, quote, standard Asian model of prostitution. The police, in an array of unconstitutional tactics, ended up faking a bomb scare at Orchids so that they could install secret video cameras. They monitored the employees and the customers in real time for 5 days. Police arrested 24 men and several female spa workers and owners. State Attorney Dave Ehrenberg held a press conference the next day. He boasted that his office was fighting, quote, modern-day slavery, and ensured that if the women spoke up, they'd be protected from criminal charges and deportation. But when pressed by the media, Ehrenberg admitted the case didn't involve trafficking. A few months later, an assistant state attorney confirmed in court, quote, there is no human trafficking that arises from this investigation. The men's misdemeanor charges were largely dropped or broken down to minor infractions. But the 4 Orchids employees, the women, were hit with an array of misdemeanor and felony charges. The owner, 58-year-old grandmother Hua Zhang, and the 39-year-old manager Li Wang both faced over 20 years in jail. Similar raids have been going on for years. In 2005, the FBI, in coordination with local authorities, executed Operation Gilded Cage, one of the largest prostitution interdiction raids in US history. On a Thursday evening in San Francisco, 400 plus armed officers descended upon Korean-owned businesses suspected of human trafficking. A neighbor remarked, quote, I thought they were going after Osama bin Laden. 102 women were rescued/detained. Most ended up in deportation proceedings, and some who were reluctant to admit trafficking victimhood were jailed as material witnesses and forced to cooperate with prosecutors. Consider also the case of Rhode Island. In 1980, a lawsuit by a sex workers' rights group challenged the prostitution law and prompted legislative change, which made sex for money, also called indoor prostitution, legal. Despite that change, police continued to raid brothels. In 2003, a raid called Operation Rubdown prompted a lawsuit, and the Supreme Court made clear that sex for money was not a chargeable offense. But that case coincided with a wave of public frustration over the growing number of Asian massage parlors in Providence, and it spurred legislative attempts to recriminalize prostitution. But they all stalled because of civil libertarian concerns over arresting the women. That is, until 2009, when Democratic Representative Joanne Giannini joined with Rhode Island University Women's Studies professor Donna Hughes and reframed the prostitution issue as anti-trafficking and gender justice. Giannini reformulated the prostitution criminalization bill to include an affirmative defense of being trafficked and introduced it with a tough on trafficking bill. The effort drew the attention of the Rhode Island Anti-Trafficking Coalition, which held rallies on the eve of the vote to support the legislative package. Korean spa workers, many using translators, met with legislators to urge them not to pass the bill. 53-year-old Sonia Williams asked lawmakers to hold off until her 20-year-old daughter graduated college. Quote, I need a little more time to help my daughter, she explained. Asian workers also testified during the hearing. One 31-year-old explained that providing services to men who are, quote, depressed or who just can't meet girls earned her far more than the $7 an hour she could otherwise earn with no education and no language skills. Despite these voices, with feminists and law enforcement aligned, the bill passed. Today, now a decade later, the Rhode Island legislature has introduced a resolution to study decriminalizing indoor prostitution. So, I've tried to show that feminists' rigid focus on individual men's bad acts and under-enforcement produced myopia on how criminalization would impact the larger and longer quest for gender and other equality. Feminist theorists Ellen Dubois and Linda Gordon once remarked that as feminists advanced through the minefield of sex and politics, they were so busy, quote, looking only to their feet to avoid the mines, that they missed the horizon and the vision of why the advance was worthwhile. Feminists' important crusade for gender justice can easily collapse into simple carceral politics precisely because it was and remains so difficult to imagine a world where criminal law does not rule the roost. But we must imagine it otherwise. To quote criminologist Nils Christie, and to finish, quote, the size of the prison population is a result of decisions. It is only when we are not aware of our freedom to choose that the economic material conditions are given free rein. We are free to choose. Thank you.
Thank you so much, Professor.
I'm done.
Yeah, absolutely. Thank you so much for that wonderful talk, really insightful. And we're going to pass along to the next panelist, Chinyere, Ezie.
Good afternoon, everyone. Okay. Well, I'm very pleased to be with you today, albeit in a rather unconventional format, but it seems as though we'll be getting used to life on Zoom for the long haul, at least for the time being. So my talk today is called Not Your Mule, the political prowess and powerlessness of Black women voters. Now, as speakers have been surfacing all day today, even though the 19th Amendment granted women the right to vote in 1920, for Black women, the right to vote remained theoretical for nearly half a century longer, though not for lack of trying. In the months following ratification of the 19th Amendment, Black organizers mobilized across the Deep South to assist Black women in registering to vote. Colored women's voter leagues were formed in states like Texas and Alabama to support aspiring voters as voter suppression tactics like poll taxes, literacy tests, and all-white primaries were expanded and perfected. And despite these challenges, thousands of Black women were successfully registered to vote in 1920 and 1921, including in southern states like Georgia, Virginia, and South Carolina. Now, voter registration also made Black women targets for racialized violence. And while we know the 15th Amendment allowed for sort of a playground or laboratory of sorts for racialized violence to really be perfected when it came to suppressing voting, the 19th Amendment is actually thought to have reinvigorated the Klan in many parts of the South and Midwest and sparked a revival of their hate violence that ultimately did cross gender lines. These slides show a little bit about the types of perils that Black voters faced. It's looking at the period that began with the 15th Amendment and pressed forward, but you see here that people who tried to exercise their right to vote could be subject to lynching. People who tried to organize and register voters were sometimes victims of this type of racialized terror. And then Black women who complained about the spate of violence that accompanied civic participation could also find themselves targeted for racialized violence. And so you have people like Fannie Lou Hamer, a very prominent voter rights activist who famously said that until 1963 or 1964, she wasn't even aware the 19th Amendment existed because voting had been so thoroughly quelched in Black communities in the Mississippi Delta where she resided. You know, she became a very prominent voting rights advocate, but herself became victim to state violence in the form of police brutality when she was accompanying a group of other organizers to a voting rights workshop. And I do want to sort of emphasize the state-sanctioned character of the racialized terrorism that Black voters and women voters faced. If it wasn't the law enforcement officers who were participating in some of these forms of brutality, it certainly was community members, Klan organizers doing it with state sort of complicity and turning a blind eye. Now, I put these pictures of Fannie Lou Hamer here to really highlight how, despite the real perils that Black women voters faced, it did not succeed in totally eliminating their thirst for the vote and their attempts to sort of claim it. And so, you know, Fannie Lou Hamer tirelessly organized for voting rights in Mississippi and lobbied the DNC, the Democratic National Convention, for its kind of indifference to Black voters in her community. Amelia Boynton Robinson, who was beaten within an inch of her life during Bloody Sunday in Selma, Alabama, was to secure the right to vote decades after the passage of the 19th Amendment. And ultimately, those efforts bore fruit with the passage of the Voting Rights Act of 1965, which really did finally turn the tide for Black women voters, particularly in the South. Now, interestingly, white suffragist organizations, including the League of Women Voters, observed the disenfranchisement of Black women, particularly in the South, with a degree of apathy and disinterest. In effect, this presages the racial fissures that emerged within feminism. It may also explain why, to this day, there is really no discernible women's vote. Rather, there are much more alignment when it comes to voting when you look at racial categories as a cross-section. Now, if you fast forward to today, what you see are that Black women are perhaps some of America's most prolific voters. For more than a decade, Black women's turnout as a percentage of the citizen voting age population has consistently been among some of the highest across demographic groups. This chart shows turnout data for the last two presidential elections in 2012 and 2016. And while it's clear that Obama's last run for presidency in 2012 exerted a particular boost to voter turnout, particularly among Black women, across years, Black women are some of the voters who have the most consistent turnout across demographic groups. Now, the level of participation of Black women voters relative to others has led historian Liette Gidlow to dub the legacy of the 19th Amendment as producing, in effect, a Black women's vote. What we've also come to observe with Black women is that they are reliable and consistent supporters of Democratic candidates. This table shows voting patterns in 3 recent elections, 2012, the presidential election, and 2016, as well as 2018 when we had the midterms. And in each of those years, you see that Black women voted overwhelmingly for Democratic candidates, and to a much greater extent than women of any other demographic group. I will acknowledge one limitation of the data that I included in this presentation is that we were not able to capture the voting patterns of Asian women and Indigenous women. Certainly, I do want to acknowledge that the face of America is changing to be quite more than black and white, but there are real limitations in the data, particularly when you're trying to do an intersectional analysis that considers both race and gender. Now, Black women also have far more consistent support of Democratic candidates than men of any demographic group. That includes Black men, and as you can see, white men have only had a minority support for Democratic candidates in the past 3 elections. So at this point in time, Black women's electoral force can hardly be debated. In fact, Black women, and I included this picture, are credited with handing Alabama its first Democratic senator in more than a generation. That's, of course, Doug Jones, who successfully ran for office with 98% of Black women supporting his bid to outpace Roy Moore, a successful bid. Black women also turned out to this year's presidential primaries with such force that Joe Biden has become the Democratic frontrunner, despite losing both the Iowa caucuses and the New Hampshire primary. For those of you who are electoral nodes, you probably will note that this flips all the conventional wisdom around presidential primaries and who's able to ultimately secure the nomination. Importantly, however, Black women's embrace of voting and political participation has not meaningfully increased their political power. At least, that's what I assert. Black women experience poverty at rates only exceeded by women in Indigenous communities. Black women also experience rates of mortality that are higher than white women of all age brackets and all stages of life. In recent months, you've probably heard about how maternal mortality statistics around Black women are particularly dire, but even suicide rates are higher on average among Black women than their white counterparts. And perhaps unsurprisingly, Black women are also disproportionately impacted by mass incarceration. They are twice as likely to be incarcerated as their white female peers. And Kimberly Crenshaw, the legal scholar, has also done some brilliant writing about how Black women and girls are targeted for school pushout and how Black women are vulnerable to violence and ultimately death at the hands of law enforcement at increased rates, particularly when they experience mental health episodes. I do want to take a moment to highlight the experiences of Black trans women who are a minority within a minority and experience unique forms of marginalization. Black trans women, relative to even other types of transgender people or transgender people of other gender expressions and racial backgrounds, experience frequent discrimination in housing, education, and employment, levels of poverty and homelessness that are really kind of extraordinary. In a 2015 survey, 51% of Black transgender women reported that they were either currently or formerly homeless. 19% of Black transgender people who were surveyed at the same time reported living in extreme poverty with an annual household income of less than $10,000. And unsurprisingly, the types of discrimination and social exclusion that transgender people face, particularly Black transgender women, has led them to be vulnerable in unique ways to gender-based violence, as well as involvement in justice systems and the system of mass incarceration. A recent study showed that 47% of Black transgender women had been incarcerated over the course of their lifetimes. And relative to the population, the offenses that lead to their incarceration are typically what you could refer to as survival-related crimes, things that stem from the poverty and economic desperation that they experience, such as theft and survival sex work. Now, there are countless other ways that we can measure the well-being of Black women relative to other groups, but I think in the interest of time, I'll stop here. But what should be clear at this point is that Black women's relationship and, their standing in the community and their political power, if anything, has an inverse relationship to their levels of political participation. I would argue that that's actually by design. Stated simply, by being reliable Democratic voters instead of a swing voting population, the type of voters that are aggressively courted by the political establishment, Black women have cemented their electoral irrelevance. That's to say, Black women's eager and enthusiastic use of the right to vote that the 19th Amendment paved the way for has led to their disenfranchisement in electoral politics. Now, part of the challenge that Black women voters face is what I term the problem of being a trapped constituency in a two-party system where the legacy of Republican Party as a party identified with white identity has been solidified in years following the 19th Amendment. Black women often don't have a viable alternative to supporting the Democratic Party establishment. And so to some extent, there's an understanding that among Democrats that there's no real risk that Black women will defect to the Republican Party. Within the Democratic Party, I argue that Black women's needs have been slow to be prioritized, and that stems from what is perhaps an intersectional failure that is embedded in their voting habits. By intersectional failure, I mean the tendency of Black women to consider the intersecting needs of communities, of a broader community, at the ballot box, but ultimately at expense of their own interests at many times. An example of intersectional failure, I would argue, is Black women throwing their support behind candidates with mediocre records on race and gender, because they are nevertheless perceived to be a lesser evil, and specifically in the case of Biden, the candidate most likely to oust Trump. And while Black women voters have rightfully decried the notion that it is their duty to save America from itself, Black women's thunderous anti-Trump vote in 2016, while others capitulated or stayed at home, suggests that, however reluctantly, Black women have assumed the role of caretaker when it comes to American democracy. So in conclusion, although Black women have fought longer and harder than any other group to see the promise of the 19th Amendment actually realized, and have gone on to become a constant presence at the ballot box, voting at times against incredible odds, not to mention increasing attempts to suppress their vote through, nouveau attempts at voter suppression. Black women's electoral taken for grantedness represents a real and direct threat to their continued prosperity. Going forward, I would like to see Black women strategize how to become a proverbial swing voter so that the political establishment prioritizes their needs, even if the only tool they can wield is turnout. Thank you.
Thank you, Ms. Ezie, for your important and insightful remarks. I'm going to pass off the reins to our third panelist, Diana Flynn.
Thank you very much, Quentin. Thank you to the panel for having me. I'm absolutely delighted to participate in this discussion, and I'm particularly delighted to talk about trans litigation at a time in which we're at the absolute crossroads for the movement. For years, the movement has focused on a sex discrimination model to protect the rights of transgender individuals, pending before the Supreme Court, now under submission, are 3 cases considering the question of whether and the extent to which Title VII and its sex discrimination provision prohibits discrimination based on LGBT status, 2 of the cases involved alleged discrimination based on sexual orientation. The 3rd case squarely presents the question whether Title VII sex discrimination provision prohibits discrimination based on transgender status. Whatever the court decides on that, obviously the movement will continue. I'd like to go back and look at the origin of these arguments and the sex discrimination model as used in the courts by movement litigators. I'd like to discuss the case that's currently teed up for the Supreme Court. And I'd also like to make the argument that whatever happens in that case, constitutional arguments beyond the sex discrimination model are already playing a more important role in impact litigation in this area and will continue to do so. When we go back to consider why the sex discrimination model was developed, there's a couple of basic points to consider. As Chinyere was saying a few moments ago, the trans community generally is a quite marginalized community. In a couple of the surveys, one of which she cited, there was the trans community reported discrimination at every turn in their lives, enormous levels of poverty. In the 2011 survey, for example, 4 times as many a percentage of trans individuals were living in extreme poverty, that is with total incomes of below $10,000 a year, than the population as a whole. It's so bad, in fact, or was so bad, in fact, that 41% of the group, they had the wherewithal to respond to the survey, had either attempted or seriously considered attempting suicide. That to me is a jaw-dropping statistic, particularly when you consider that these people that are reporting are the winners. They're the people whose suicide attempts did not work. I hesitate to think of how many people in the population as a whole have had those thoughts and made those attempts. Now, believe me, the situation was no better 25 years ago. There were few allies politically of the trans community. In fact, when the Employment Non-Discrimination Act was considered by the Congress, which would have prohibited discrimination based on sexual orientation, many LGBTQ groups acquiesced in the removal of anti-trans discrimination from that act. Now, what this meant is that a marginalized community that was very politically powerless and found few allies had to look at existing law and see what they could find in existing law to make their arguments. Luckily, Title VII's language provided a potential recourse, as did the language of other federal anti-sex discrimination acts. Title VII prohibited adverse employment actions by covered employers that are taken because of sex. Now, way back in the 90s, many people, at least in the Civil Rights Division at Justice, were asking the question, why doesn't that prohibit discrimination based on trans status? If such discrimination is not because of sex, just what is it about? The obstacle, however, was you could hardly argue that that was the purpose of Congress in enacting Title VII. You might ask what the purpose was, since Title VII was introduced on the floor and at least some people supported it as a poison pill, hoping it would sink the entire act. But clearly, none of us would argue that Congress at the time had in mind protecting trans people. So there was a reluctance to hang our hats on that particular argument at the time. But what was happening at the same time was in conservative jurisprudential circles, there was arising an argument which was espoused by many advocates, including some people that are currently on the Supreme Court, that regardless of what Congress intended, or regardless of what the result is, you simply look at the plain language of a statute and give it the full effect according to the language. This led to a decision by the Supreme Court, which actually was written by conservative icon Justice Scalia in Ancala versus Sundowner Services, in which he said the original congressional expectation doesn't matter, only the words of the statute do, in holding that Title VII could be read to cover same-sex sexual harassment, even though that was perhaps the furthest things from Congress's mind when it voted on the bill. So given the growth of that conservative legal philosophical view and the availability of the plain language, the movement has largely relied on the sex discrimination model. And with respect to trans rights, and in addition with respect to sexual orientation. But with respect to trans rights, we've had enormous success over the years. Court of Appeals after Court of Appeals have either under Title VII or Title IX found the applicability of federal anti-sex discrimination laws to anti-trans discrimination. A lot of progress has been made, and the community has moved forward with that. As I said, the Supreme Court, which is much more conservative now than it was when most of these cases were litigated, will now have something to say about whether that view is valid. Of course, if the court does hold that there is coverage, people like us at Lambda Legal and other advocates will take that decision and run with it. If the court does not, we'll take a look at the decision and see where we can go from there with respect to Title VII, Title IX, etc. But either way, in my view, constitutional arguments are going to be more important as we go forward. The reason is because a lot of the litigation and hostility that the trans community is facing now is the result of continued attacks, often supported by governmental entities, on the trans community. We see that almost every day from the Trump administration as it issues regulation after regulation and rolls back protection after protection, and issues some regulations that we have argued actually encourage discrimination against trans people, among other things. We see it in many state legislatures, some of whom have not even stopped during the pandemic and have gone ahead to pass legislation undermining the rights of trans people, and specifically intended to do so. It is going to be necessary to interpose constitutional protections to face those threats and future threats, regardless of what happens to the sex discrimination model. I'm going to propose two lines of argument that will be of importance in my view. And the first involves the coverage of the Equal Protection Clause. And I'll just say at the outset that whatever the court decides on Title VII, it is not clear that that decision will be controlling to the extent that we argue, as we have, that anti-trans discrimination constitutes sex discrimination or the Equal Protection Clause. The extent to which the Title VII view, whether it's positive or negative, will be imported to that is something we will litigate. But I'm really talking to about another kind of analysis here. And that is the argument that trans people are entitled to, in their own right, to heightened scrutiny to protect them from governmental attacks on our rights to exist and our rights to participate in society. There are two arguments that I would suggest should be made together in trying to reach that result. The first is that trans people as a category meet every requirement for application of heightened scrutiny on the grounds that they are a suspect or quasi-suspect class under the analysis of cases like Korematsu and Hirabayashi. When you take a look at it, it's hard to imagine a group that has been less popular with governments and more subject to stigma and discrimination than trans people. That's the first category. As we know now, trans status is an immutable trait. It hopefully is a trait that we would all agree bears no connection to the ability to contribute to society. Many trans people do all the time. And finally, as we've talked a little bit about before, they are a very politically powerless group. There's a question whether that is absolutely essential anyway. But if you had a politically powerless group now, it might be the trans people that are the targets of so much negative legislation, even in these difficult times. Now, will the Supreme Court adopt that rule? This Supreme Court, I don't know. Clearly, all the criteria are met, but will this Supreme Court find any other classification at this point that it will say is entitled to heightened scrutiny? So let's give them an out. At the same time we make those arguments, we should also rely on cases like Cleburne, Romer, and Moreno to argue that even under the rational basis clause, hostility to a particular identifiable marginalized population or reliance on stereotypes about them are simply not a legitimate, let alone a rational, governmental objective. Cleburne applied that rule to mentally challenged people. Romer applied that rule to gay people, and Moreno applied that rule to hippies. So I guess at one point, and I guess I can remember this, were the subject of a great deal of stigma. But if these arguments are made together, that discrimination against trans people should be subject to heightened scrutiny. But even if you don't want to go there, the justifications or the basis for the discrimination do not satisfy the rational basis test because they're not even a proper governmental objective. Even this Supreme Court might be willing to accept the latter point. Finally, I want to talk about the last argument, which frankly, I do not think is going to initially be successful, but I hope it's where we're ultimately going to go with this. And that is the substantive due process clause. We now know that gender identity is one of the most important and personal elements of an individual's identity. If the substantive due process clause protects against everything, it seems that it should protect against the government attempting to interfere in those essential elements of personal autonomy and their feeling about who they are, their very humanity. Now, will this court go there? Well, I certainly wouldn't rely on this argument alone. Many people on the federal courts now, including people on the Supreme Court, were selected with the expectation that they would be opponents of a substantive due process analysis, particularly what's sometimes called a right to privacy. But ultimately, I hope that we get there. The argument has the advantage of being correct, and it has the advantage of being rooted in some of the philosophy upon which our entire system is based. It also has the advantage of being remarkably affirming for those people that want to be able to recognize themselves and express their own gender identity. To that last point, I'd like to close by reading something that I always found very much in point in moving on this topic. And it's from the epilogue from Ralph Ellison's classic novel, Invisible Man. And this is the nameless protagonist. Well, now I've been trying to look through myself, and there's a risk in it. I was never more hated than when I tried to be honest. Or when, even as now, I've tried to articulate exactly what I felt to be the truth. No one was satisfied, not even I. On the other hand, I've never been more loved and appreciated than when I tried to justify and affirm someone's mistaken beliefs, or when I've tried to give my friends the incorrect, absurd answers they wish to hear. In my presence, they could talk and agree with themselves. The world was nailed down, and they loved it. They received a feeling of security, but here was the rub. Too often, in order to justify them, I had to take myself by the throat and choke myself until my eyes bulged and my tongue hung out and wagged like the door of an empty house in a high wind. Oh yes, it made them happy, and it made me sick. So I became ill of affirmation, of saying yes against the naysaying in my stomach, not to mention my brain. My problem was that I always tried to go in everyone's way but my own. I've also been called one thing and then another, while no one really wished to hear what I called myself. I hope that someday, if the Constitution is properly interpreted and enforced, government will have to be willing to hear what we all call ourselves. Thank you.
Thank you, Director Flynn, for those really insightful and timely remarks on a really urgent issue. At this point, I'd like to pass off the reins to our fourth and final panelist, Professor Skinner-Thompson.
Well, thanks so much, Quentin, and thank you to the audience for joining us for this fantastic day. And of course, I'd like to reiterate my thanks for the many people who helped put this conference together, Professor Suzette Malveaux, the other faculty coordinators in this conference, Professor Ming-Chin and Professor Carolyn Ramsey, our wonderful IT colleagues, Teresa Coverly, John Sabre, and Quentin, and the many other students from the Law Review. And of course, my fellow panelists who, I feel very lucky because I had a say in crafting this conversation. So I got to pick people that I admire and want to learn from. And certainly they didn't disappoint. So thank you, Aya, Chinyere, and Diana. With that, my project is called Identity by Committee, and it seeks to intervene in a moment when, in some ways, similar to Professor Gruber's project, trying to look at the ways in which different aspects of feminism, with all its many different contours, have nevertheless been used to exclude certain people or subjugate certain people. And I think that within the contours of the discussion about feminism, one key topic is who counts as a woman, and certainly some feminists argue and advocate for a narrow conception of feminism and womanhood, in particular, seeking to exclude trans women or trans feminine people. And the particular context I'm focused on is, in fact, the K through 12 education context. And so I'm focused on the ways in which society and law have created many different complex structures regarding whose gender identities will be recognized as legitimate and who will be included as female, who will be included as male, and increasingly who will be included as non-binary. Certain jurisdictions are beginning to recognize as genders outside of this binary construct, the state of Oregon being at the vanguard in that regard. More specifically, drilling down a little bit further, I'm concerned about the intricate bureaucratic processes that have developed to regulate students' gender and sexual identities in schools, and the harm that these bureaucratic structures do to students. Not and to put a finer point on it, it's not just our criminal laws that serve to regulate and subjugate identities, though they are the most harmful in terms of their long-term consequences. But there are all sorts of statist institutions that also shape our identities and pick winners and losers, pick who counts and who doesn't. And that begins from the outset. From the time you walk through the schoolhouse gate, the institutions are regulating our identities. And I believe that that's led to a handful of problems, which I'll talk about. But I'm also interested in interrogating, and this is the third point, whether actually many of the common frames, progressive frames for thinking about queer gender identities have reinforced rather than deconstructed these bureaucracies, sometimes unwittingly. That is, have the progressive frames for queer gender identities legitimized these statist bureaucratic structures and legitimized their exclusionary aspects. And finally, I want to explore if different conceptions or at least points of emphasis of gender identity, namely a renewed emphasis on gender expression, might hold greater emancipatory potential for queer people. So in the schoolhouse, there have primarily been, and I'm painting with pretty broad strokes here, but two approaches to regulating gender identity and who counts as a woman, who counts as a boy, who counts as a girl in the schoolhouse context. The first approach has received the most attention, and it is undoubtedly the more restrictive. And I characterize it basically as you have no freedom to decide or articulate or live consistently with your gender identity, and instead the sex that you've been assigned at birth governs. This approach to gender identity in schools is perhaps most famously embodied in cases such as that of Gavin Grimm, which for a short time reached the Supreme Court. And most of both the litigation by interest groups and popular press focus has focused on these restrictions. Schools have said no. You cannot use a sex segregated space, either the locker room, a bathroom, or participate on a sports team unless you are participating and using the space that coincides with the sex you were assigned at birth, what many people erroneously refer to as your biological sex. Many of these restrictions have been successfully challenged under the sex discrimination paradigm that Diana Flynn was describing, that they violate transgender students' rights either under the Equal Protection Clause or under Title IX's prohibitions on sex discrimination in federally funded programs, or sometimes as a violation of the constitutional right to privacy, because if a trans student whose gender expression is female is forced to use a male restroom, then they could be outed as transgender to the public. What's been given less attention is a second approach to regulating gender identity in the schoolhouse, an approach I call identity by committee. And under this approach, a student may be able to live consistently with their gender identity and access sex-segregated spaces and activities, but only after consultation with a host of purported stakeholders. And that list can be extremely long and onerous. It can include medical consultations with a doctor. It can include mental health consultations with a therapist. It can involve insights from their teachers, from the administrators. It can involve feedback from administrative lawyers. It can involve getting the permission of the students' own parents. And as we've seen in some cases, such as the Gavin Grimm case, it can involve hearings before the entire school board in public. And those hearings can include the community and other students and parents are given a voice and a say over a particular student's gender identity. Sometimes some states, such as the state of Washington, which I'll get to in a moment, have even created specific gender identity committees or adjudicative bodies to regulate these students' identities. These policies are sometimes ad hoc and unwritten. That is, schools are just reacting and coming up with policies on the fly in response to increased vocalization by trans students of their rights and their identities. But increasingly, the policies are often being put to paper. Again, the identity by committee approach is viewed as the emancipatory approach, right? Like, this is the good solution. It's preferable to the no freedom solution. I agree that it's preferable, but it is not without significant costs. And before getting into those costs, I'm just going to give a couple of examples of, real life examples of identity by committee. So in a case from the Third Circuit called Boyerton Area School District, BASH, the school district's policy, trans-inclusive policy, was challenged by a group of parents who didn't want trans students to have access to sex-segregated spaces consistent with their gender identity. BASH had an identity by committee. They permitted trans students to access segregated spaces, but only after a rigorous process and what they labeled as a careful process that included each student being analyzed on a specific case-by-case basis. And I think some of the language in the Third Circuit's opinion is reflective of how the committee is designed and built to. There's a built-in assumption of skepticism and delegitimizing of a trans student's identity. The Third Circuit Court writes, the district required students claiming to be transgender. So the starting point here is, the student is claiming that, that they are just asserting this without it actually being their identity. And then that student is required to meet with licensed counselors, principals, school administrators, and a lawyer. The Washington Interscholastic Athletic Association policy on gender identity is really complex, and it provides a process for those outside of the student's family to challenge the participation of the student. And once that happens, the school district has to advise the parents and legal guardian of the student, potentially putting the student at risk if the parents are not supportive of the student, and then a facilitator is assigned to weigh in, and then after the facilitator's decision, there's an appeal to an eligibility committee that will hear, quote unquote, gender identity appeals. The Gender Identity Eligibility Committee includes a physician, a psychiatrist, a psychologist, a school administrator, the athletic association staff member, and an advocate familiar with gender identity and expression issues. So again, a progressive, purportedly policy seeking to allow trans students to participate. You can imagine this is an enormous barrier to actually living your life consistent with your gender identity. You need to have, in the first instance, supportive parents, and then you need to have the social capital and wherewithal to navigate this entire process. Why is the identity by committee problematic? As I just mentioned, it's a huge hurdle or deterrent for children seeking to live consistent with their identity, gender identity. Second, I believe that it reinforces the need and the primacy of official recognition of identity by state institutions. It says, no, before you get to be who you are, what the state says matters, and you have to go through this entire process, and that's going to determine how you are defined. I believe it also reinforces parental control of student identity, which may be exceedingly problematic for the many, many trans people who do not have parents who are supportive of their identity. Certainly, there are many reasons for the trans youth homelessness that Chinyere so powerfully underscored. But one of the reasons is that some trans kids are not supported by their families. It leads to disenfranchisement from their families and homelessness. And this process reinforces parental authority. I also believe that to the extent that these committees require the involvement of doctors and therapists, that these committees are reinforced the pathologization or medicalization of gender identity, and the idea that it is in somehow in need of medical treatment. Now, that's not to say that medical interventions aren't needed and cannot be emancipatory and haven't been emancipatory for many trans and gender nonconforming people. They can be, but while they may be needed in some instances, I do not think that they are universally needed. And even WPATH recognizes that, the World Professional Health Association for Transgender Health recognizes that, for example, surgery is not necessary for every trans person to live consistent with their gender identity. But I think that these committees reinforce that as being a necessary component of someone's transition. Fifth, it often gives other people outside of your immediate community control or a say-so over your identity, and who's to say they should have that right. Sixth, each new person who's included in the committee amplifies the privacy risk, and that there would be a disclosure of intimate information regarding the students' medical information or transgender status. There are probably others, and I'm very much welcome other potential downsides that folks see with this approach. So where did this committee come from? I think in part, as I gestured to at the beginning, it's a product of the ways, some of the ways gender identity has been framed even by progressive organizations, and real candidly, I've contributed to some of these frames. For example, as I just discussed, the committee often gives emphasis and deference to parental control, and I think that is, the LGBTQ community has at times embraced that, and that's good enough when you have parents who support their children, but problematic when they don't. I also think that the reliance on the sex discrimination frame that, as Diana Flynn underscored, has been really prevalent among the LGBT movement has reinforced the idea that you need to prove that you are a particular sex and that you fit into a particular box. The LGBTQ movement has also embraced the medicalization of transgender identity, and for example, the need for surgery to treat dysphoria. And again, while that may be true for some, that has legitimized and led to the sometimes requirement of a doctor or a therapist giving someone's identity a stamp of approval. I also think that the emphasis on medicalization and the sometimes need for gender confirmation surgery perhaps puts too much of an emphasis on a conformist or physical view of our sexed bodies. Obviously, sex involves sex-based characteristics and gender external genitalia, but it involves many other characteristics, and the most important is your internal sense of what your sex or gender identity is. And I think that perhaps the emphasis, particularly in the adult context, on gender confirmation surgery has implicitly supported the concerns of cisgender students and their parents on bodily privacy and bodily difference. That is, by arguing that, oh, we need access to gender confirmation surgery to alter external genitalia, does that unwittingly and implicitly suggest, okay, external genitalia really is super, super important, in effect legitimizing the emphasis put on anti-trans activists of bodily difference. I also wonder if the emphasis on trans privacy rights has given implicit support to the concerns of cisgender students who claim, oh, the presence of trans people is going to be a privacy violation for me. So all told, I think that the origins of the committee in many ways are a product of the way that gender identity has been framed by progressive LGBT movement activists. And I wonder if there might be a more emancipatory frame by emphasizing gender expression. And to be clear, expression actually was the LGBTQ movement's first constitutional foothold. Long before sex equality or LGBT equality rights were recognized, expression was used by gay and lesbian, for example, gay and lesbian teachers to challenge their firing in the schoolhouse as being an infringement on their gender expression. And I wonder if a return to this approach may have benefits for gender nonconforming and trans youth. In the schoolhouse itself, queer kids have been, their expressive rights have been recognized, their First Amendment rights. They've been granted the right to wear gender nonconforming clothing, such as prom attire that doesn't correspond to the gender they were assigned at birth. They've been allowed to wear queer religious clothing, for example, a rainbow isthmus or Jesus fish. And they've been allowed to engage in gender nonconforming expressive behavior, such as bringing same-sex prom dates. So, and these are all examples where the First Amendment has been used to secure the freedom of queer kids. Importantly, not only is the First Amendment really robust in terms of the level of scrutiny it generally requires, but kids haven't been required to get parental approval or medical approval before asserting their First Amendment rights within the schoolhouse gates. The most common response to students who try to assert their expressive rights in schools, the big defense used by schools is, oh, this is disruptive, okay? But I think that to the extent schools raise that as a defense to kids' gender expression, that provides an opportunity to explain why expressing someone's true gender identity doesn't actually harm anybody else, doesn't disrupt anybody else, allowing queer kids to rebut the purported countervailing privacy concerns. So in addition to those doctrinal concerns, I think that there are also, maybe even more importantly, some real discursive benefits to the expressive framing. Namely, I believe that it gives queer youth an opportunity to explore and educate society in the ways in which identities are socially and contextually constructed. That is, it arguably provides a better avenue for giving legal life to what queer theory has taught us about identity. And what is that? That is that our identities don't exist in a vacuum. They're not preternatural or a priori, but instead they're socially constructed, the product of biology perhaps, but also the product of socially constructed forces. And when students go against those forces and start to construct their own identities, not only under First Amendment law will their identities be seen as expressive in the heteronormative social construct, but they begin to educate society on those same social forces and can begin to deconstruct the walls that have been used to confine those identities. So thank you very much.
Thank you so much, Professor Skinner-Thompson, for bringing light to an evolving and complex and timely issue. At this point, we have completed our panelist presentations, and we are going to move into the Q&A portion of our panel. Before we jump into the audience's questions, I wanted to give our panelists an opportunity to ask questions of one another or make a comment in that vein. If you do, just unmute yourself and go ahead and speak up.
I had a question for Professor Skinner-Thompson. Assuming that there was a movement toward protecting gender expression in the schools on those terms, I'm wondering how the treatment of the school, of the individual involved fits into that. You know, a lot of when someone is seeking to live their identity and have a real life experience, part of that is to be treated and respected as the gender to which you identify. Would in your view, would a part of the enforcement of the freedom to engage in gender expression include respect for the gender identity of the student?
Oh, absolutely. And you know, my sort of hypothesis is that the gender expression is the better way to get recognition of that gender identity, that viewing someone's assertion of their identity as an expressive act will require the school to acknowledge it, not squash it, not regulate it, and give life and recognition to that expression without all of the rigmarole and hurdles that are currently being built up.
I also really benefited from the presentations of my co-panelists, and something that I was left reflecting on was, and sort of ties into sort of questions I grapple with in my career as a civil rights lawyer, is sort of how much harm do we do with our good intentions when it comes to policy. And I think, Scott, you, Professor Skinner-Thompson, you gave some examples of how the identity by committee, to some extent, is a progressive invention that's designed to sort of create balancing tests and sort of secure the rights of trans students, you know, while considering other considerations. And Professor Gruber, I was thinking of a similar tension when you talked about anti-trafficking work and how, you know, a lot of the work to criminalize prostitution, including prostitution or sex work that is voluntarily engaged in, is under the auspices of protecting women from trafficking. And just curious if we feel like that this is sort of a problem of visioning and sort of failing to anticipate consequences, while nonetheless acting with perhaps good intentions.
Go ahead.
Okay, sorry, I had to unmute myself. Thanks for that question. And I actually had a question back for you, Chinyere. But, you know, in terms of reform and feminist reform, I do think that when you start to consider some of the past reforms that you see interface with larger phenomenon and the strategic compromises that may have, you know, not only unwittingly or wittingly reinforced racial and class hierarchies, but ended up harming sort of women who intersect with other marginalized identities, you can feel extremely paralyzed, right? That reform can happen. So the way I think of it is, there's a great book out right now by two Yale professors, I'm forgetting the last name, and Mindy Roseman, and they talk about a politics of accountability. That especially if you're using the painful tools of incarceration, you have to be accountable to the calculus of using those tools. And one of the things that I try to, through stories, illustrate in my book is that I think that there was almost a religious type of faith in criminal law, where there was a move long ago where, because under enforcement was the narrative, criminal law and enforcement became justice in and of itself. And it kind of thwarted that more utilitarian or distributional calculus. So, so I think, yeah, like it's always possible that reform, as well as intended as it may be, may have backfiring effects that are unpredictable. But I think some of the story of feminist criminal law reform is actually a more predictable story, and it has a pattern to it that, if we understand, can save us from mistakes now. And so that's my answer. But if I could ask a question for you, I thought that your proposal of Black women voters being swing voters is completely radical, because it implies that Black women should pretend or actually vote for very conservative, voices. And so I'm just wondering what the reaction has been to that proposal.
It's I'm still soliciting feedback. As someone in the intended demographic, I don't think the invitation is to sort of vote for Trump 2020. I think it's actually to just think about ways to sort of make our vote conditional. So the question is, do I vote, as opposed to realistically, who do I vote for, at least once you're out of the primaries. But I don't think that Black women should continue to play this caretaking role for democracy if, when people are elected, there's actually no attempt to sort of tend to the needs of that electorate. And if the swing voters are always going to be the more coveted group when it comes to sort of both political promises and sort of executing demands. So I don't know if that adds a little bit of nuance, but I think ultimately the power that we wield is to decide not to vote, arguably not to make a overture to the Republicans.
Ms. Ezie, I would also kind of like to ask a question related to that inquiry. Namely, is there any historical precedent for a demographic or group of voters who have kind of been able to transform themselves in such a way where they were taken for granted, and then they made their vote conditional, and in doing so made themselves more relevant politically?
That's a great question. I mean, I think that there's a extent to which, the white voter base has always sort of had that status in this country. I mean, there were attempts to really sort of unify, people across racial lines just based on class politics. And, I think the story of Reconstruction is basically all the moments in history where there's been a backlash about sort of these moments of possibility that are created from sort of thinking more expansively about politics. I think that the fact that 53% of white women voted for Trump is significant, and I think that puts, in my view, white women as kind of a coveted voting base going forward to sort of see what kinds of political promises you can assemble to sort of bring them back to the fold. And I would say, and I think it's a limitation of both what I was able to present, but also the data that I've encountered, is just kind of the political power that's occupied and that's held by all of these other emerging minorities within the U.S. context, who have their own different proclivities and less reliability about how they vote, whether that's Latinx voters, whether that's Asian American voters. I think anyone who sort of is not necessarily taken for granted voter has some leverage in the political system that I think should be explored.
Great, thank you for that answer. At this point, I want to take a question from the audience. And Professor Gruber, this question's for you. So you've spoken about how the feminist movement has often turned to carceral responses to what have often been characterized as quote unquote women's issues, such as prostitution and domestic violence, and how that fails to recognize the intersectional experiences of many women while essentializing them as well. How, if at all, does this relate to the current Me Too movement? And how can feminists avoid the carceral impulse while addressing the real problem of sexual misconduct and harassment?
That's an excellent question. And I think with Me Too, there's been just a wave of awareness and activism when it comes to violence against women. And that is a great part of Me Too. Another great part of Me Too is sort of this shedding the stigma of being a violent survivor. So, so I'm not going to, criticize Me Too movement as a whole because it has the potential to be carceral, because there are many amazing things that came out of the Me Too movement. But at least a part of the movement is about focusing on certain bad sexual actors like Harvey Weinstein, and imagining that many of the people who the criminal system goes after are people like that, people who are generally immune from the criminal system because of their power. So the criminal system then not only is sort of an individual retributive system, but it also produces sort of class and economic equality. And what I want to say about that is a false perception of the criminal system. Although maybe it worked against Weinstein, and we could talk about that. The criminal system does an amazingly good job of managing the most marginalized people and imposing discipline on them. And I think I think we could hold out hope that the criminal system is there to equalize and bring down the powerful and be a tool of gender justice. But I think when you look at it over many, many years, it has generally failed in that endeavor. And so I would say that we should take these Me Too energies where people are being very cognizant of the problems against violence against women and not invest them in the prosecutorial responses and in a carceral system that has so many embedded idiosyncrasies and logics and players that it's very hard to rearrange it from the inside and start looking to some of the other groups like, for example, Incite on the domestic violence front, other police and prison abolitionist groups that are run by women that are doing community justice and transformative justice. And also like direct service providers. If you look at the sex trafficking, there are many direct service providers that are making it clear to courts that they can reach the women without interposing an arrest and a movement to prostitution court and then getting the services in between without that sort of carceral management. So, I mean, I think this can be done when feminists, and they've started to imagine that progress is neither just writing off violence against women as not a pressing issue, but nor is it presuming that the way to handle violence against women is more policing, prosecution, and incarceration.
Thank you for that comprehensive answer. The next question from the audience is for Director Flynn. So an earlier presenter argued that the Equal Rights Amendment's use of the word sex might be interpreted to broaden the scope to people of all genders. As a textualist and an LGBTQ advocate, I worry about that language, says this questioner. Do you see that as a potential flaw in the current Equal Rights Amendment?
No, I'm very supportive of the Equal Rights Amendment. How it's going to be interpreted will be very interesting. And I know, of course, I'll be making the argument that it should be interpreted to provide equal rights for gender minorities, including trans people too. But the plain language argument, it does not really work as well with respect to a constitutional provision as it does for a statute. Constitutions aren't intended, in my view, to be written like codes. Often broader language is used. Now there are real differences depending on one's jurisprudential philosophy on how you interpret a constitutional provision. But even the people that are sort of on the conservative side of the spectrum often adopt more of an original understanding or originalist approach rather than simply relying on the plain language. I eschew that kind of approach generally, but I think it would have a particular difficulty with respect to the Equal Rights Amendment anyway, because what original understanding do you look at? The amendment has been pending for decades now. I would argue probably that this should be, the meaning of sex should be interpreted in accordance with the modern, accurate scientific understanding, and therefore, could be broadly applied. But, again, I think that different arguments and different analysis will apply than sort of the plain language argument that we were discussing with respect to Title VII and Title IX.
Awesome. Thank you for that answer. And Director Flynn, I'm actually going to stick with you because I have a question. I'm curious. You have a unique perspective because you have served as an advocate for LGBTQ plus rights from both inside the government and out. I'm wondering if you could expand on some of the pros and cons of your current position, especially in light of the shifting priorities of the DOJ.
Well, I'm absolutely delighted to be where I am and doing what I am, and part of the reason for that are the shifting priorities of DOJ. I found I left in early 2018 after giving it about a year, and thought that as a moral matter, if I stayed at DOJ, I had the choice either of collaborating with efforts to roll back civil rights generally, including LGBTQ rights, but not limited to that, or trying to stay out of the line of fire and keep my head down. I didn't find either one morally tenable. But being at Lambda Legal lets me be on the side of the angels again on something I feel very strongly about. So they're related, but I'm certainly glad I'm where I am. I'm glad I'm where I am at this point.
Thank you. Professor Skinner-Thompson, next question I have is for you. Are there any instances where a greater emphasis on gender expression as an operative factor have been implemented to define gender identity? And if so, what have been the results?
So it's been brought up in cases, for example, I think including in some of the cases that Lambda has litigated, challenging restrictive birth certificate or gender or driver's license gender marker cases in Puerto Rico and Idaho. I think Lambda included both privacy arguments that not allowing someone to have an identification document that corresponds to their gender identity violates their privacy, because when they show the ID to their employer, for example, then they might be outed as trans. They also included some First Amendment arguments arguing that requiring a trans person to have a document, a government-issued document that doesn't correspond with their gender identity constitutes compelled speech that and that doesn't align with their identity. So it has been raised so far in those cases, and Diana can correct me if I'm wrong. The courts have, generally speaking, found for the trans plaintiffs, but usually on privacy grounds or equal protection grounds, but they haven't, to my knowledge, rested the opinions on any free expression grounds. But as I said, I would say gender nonconforming and gay kids have had a lot of success with the First Amendment in the schoolhouse context, even, and so I think those cases provide a lot of promise.
That's great. And Scott, I'd actually like to stick with you. I'm curious, as a matter of policy, about the impact that a child's age has on the degree of autonomy or weight that's given to this to gender expression. You know, for instance, should a 15-year-old have substantively the same rights as a 10-year-old?
Well, I think that you know, to be clear, like if you're in terms of medical interventions, you know, I think a lot of the arguments that get raised about trans youth are don't do surgery, for example. But actually, if you look at the WPATH recommendations, like they don't advocate doing surgery that young. But I think that it's just as important that a 10-year-old, that a 5-year-old be able to express their gender identity as it is for a 15-year-old, arguably even more important, because gender is being formed from day one, okay, you know, before day one, but also from day one, it's being socialized, right? And so I think, yes, it's critically important that young kids have a wide degree of freedom and autonomy to express their genders in any way they deem appropriate, without having to go to a school for permission to do so. And I'd love to get Diana's perspective on that same question.
In terms of the First Amendment, it's absolutely right that we have been, you know, relying on that argument in terms of both both our student cases and our birth certificate cases, and I do think that compelled speech is while we have not. You know, you're right, the courts have not focused on that particularly. I think it is a profoundly important argument in these contexts. Because when you're taking something that is inherent to the struggle that a lot of trans people have in their lives, and and consider that a trans person has already been struggling against forces of society telling her that she is something that she's not. And then you make her go out and profess that. Compelled speech is never a good thing, but given the topic and the background of the person you're dealing with, it is a profound insult and humiliation. So, and that's true to the extent generally that there is regulation of trans identities, which are often tied up, particularly in the schools, which are often tied up to, with forcing people one way or another to profess or conform with other people's view of their gender. So I think it's a really significant point and a good argument. I think a lot of damage is done to trans people by forcing them not only to suppress expression, but actually to conform and make some sort of a statement that they're not who they say they are.
Thank you, Director Flynn. And I'm curious, did you have any comments on the second half or the second part of the two-part question I asked?
I'm sorry, which one was that?
It dealt with the differences that age should have on gender expression and weight. I'm just curious on.
Well, I think that there is a real, it's absolutely true that people do not recommend generally irrevocable steps for young people. I think that, age ultimately, it's not a fight I want to take on now, but you know what your gender identity is in most cases at a very young age. We do not enforce or interfere with someone that's acting in accordance with their birth assigned sex, or make any sort of inquiry like that. The only reason we might make more of an inquiry or put additional restrictions on the personal identity and expression of a young student is because we suspect they aren't real. We don't believe they're who they say they are. So in terms of expression, ultimately, I don't see why we don't allow for personal attestation and expression at all ages. On the other hand, that's not going to be the first case I bring on that is not going to be for a kindergartner.
Fair enough, and thank you for those comments. Professor Skinner-Thompson, did you want to add anything else, or?
No, I thought that was great. Yeah.
Okay.
Align myself.
Well, thank you, everybody. I think we've about reached 4 o'clock. I really had a great time today, and I want to thank all our panelists for coming, making this happen, despite the situation we are all in. And I want to thank all our audience members for coming to participate. I've learned a lot today, and I hope you have too. At this point, I'd like to hand it off to Professor Malveaux, who I believe is waiting in the wings.
Thank you, Quentin.
Okay, great. Thank you. I'm back. Thank you so much. This concludes our Q&A for panel 3 and actually for the last panel of the day. I was particularly appreciative of the civil rights lawyers who were on our panel. I used to be one myself, and I think it's really important for academics and scholars and practitioners to be working together on these issues. It's certainly important, to get out of our silos and find those synergies. So thanks in particular to that particular diversity on the panel. So it brings us to the end of our conference, and I just have a few remarks to make, but I'm reminded this whole day has been so enriching and so valuable, and I'm so grateful for the women who fought for the right to vote, who fought to end slavery, who fought to get equal pay and reproductive freedom. What a great reminder of the courage we need today and the importance of keeping up the fight and remembering what's possible. The struggle for women's empowerment has been going on for centuries, and it certainly continues. And I look forward to our working on this together. I want to start, I also want to sort of start by thanking so many people who made this possible. Something like this clearly does take a village. I first of all want to thank our audience. Thank you for participating. Thank you for being a part of our day. There are so many things competing for our time and attention, and rightfully so. So I'm very grateful for your tuning in and contributing to this conversation. So we certainly appreciate that. I want to remind you that we will reach out to you for the lawyers who are interested. We have 6 CLE credits that are available, so we'll reach out and give you some instructions so that you can submit the affidavit and get those credits. And I also will remind people that we're going to send out a survey, so we'd appreciate your feedback. Let us know how we did and how we can continue to grow our programming. I want to just thank those who've made this conference possible, especially once it became virtual. I would have never had the courage to do this if I didn't have complete confidence in my team. So for starters, I want to thank those who've provided research support, Jane Thompson and Amanda Blassingame. The two of you have continued to provide amazing support and in record speed at times. So thank you for that. I want to thank Julia Roth, the Director of Marketing and Communications, for helping us to get the word out. I really appreciate that. I want to definitely thank our IT folks. Our IT folks are amazing. John Sabray, who's the Senior IT Director, and Teresa Coberly, who is the IT Support Manager. So, you guys are awesome, and this went without a hitch, and so I'm so grateful. This is not my strength, as you know. And then I really finally want to thank Melissa Shenter. Melissa's our faculty events coordinator, and she has worked tirelessly with me to make this possible. So I would not have been able to pull this off without you. So I'm very, very grateful. Of course, thanks to our scholars, our lawyers, our students for their presentations and their insights, their wisdom, their brilliance. If you'd like to learn more about their work, many of the presenters are going to be publishing articles and comments in a special symposium issue of the Law Review. We will also have this recorded. We have this recorded and we will post that on our website, but please look out for that special symposium edition. I think we'll go even deeper and get a chance to take a look at their scholarship more closely. And then finally, I just want to thank all of the mothers, all of our mothers and grandmothers, and the brave women who blazed the trail before us. Their sacrifices and courage have brought us here and have brought us far. So I think I'd like to end on that note. Thank you so much. Appreciate your support, and we look forward to seeing you at the next Rothegerber conference next year. Take care.